recently, a case that caught the attention of many is that of a man who walked into the highest institution of learning in the country, the University of Botswana, and killed what is known as a former lover. Circumstances are different for each case, but the pronouncement generally is that this is gender-based violence. This is the case at the University of Botswana, or the killing of that innocent woman. And I say innocent understandably, that the woman had nothing to do with the provocation, at least at that minute. The magistrate says that the case reached that point where a life was lost because of what she called carelessness of those who were handling the case in as far as the DPP is concerned. We have here in the studio a gentleman who is very much respected in the legal fraternity for the good work he's doing. Kgosi Ngakaagae. He's actually a criminal law expert, I must say that. The attorney, Kgosi Ngakaagae, thank you very much for gracing us with your presence.
Thank you very much, my brother, and to your audience.
You are here to help us unpack the statement that was made by Chief Magistrate in the case of the woman whose life was lost on the day when it was least expected. And I say least expected because she was at the workplace. At the workplace and home, these are the two places where you will have your defenses at the lowest. And the magistrate says that this case, or the death, could have been avoided, given the circumstances, what you know so far. What's your position in her statement?
She is right in some way. I wouldn't make it an absolute position. I would rather say that more could have been done to ensure that she was safer than she ultimately turned out to be. Total avoidance is, for the most part, impossible because of the obvious vulnerabilities that we have as human beings. I mean, you can be killed going to the shop, you can be killed going to a football game. A murderer or a killer has quite a wide scope based on the vulnerabilities that we have as human beings, our freedom of movement and the necessity to keep up with our daily routines, to pick a spot where you are most vulnerable and simply take you out. So we can only heighten our guard, but to make it an absolute position would be quite difficult.
Okay, let me just read what the magistrate said. She actually says she called out the criminal justice in the country. She said it's flawed. She went further to say the situation or the life would have been saved if information was not withheld from her at the time she made a decision to grant bail. Would you say that was withholding information? And can we say that it was deliberate or it was a genuine omission of information?
It is never, or at least in my experience, it's hardly ever deliberate. Quite often, it's just inadequacy or lack of efficacy in dealing with specifically bail procedures, because the subject here was the bail question. And bail is a technical subject. There are many things that go into the melting pot in determining whether or not to grant bail in any given situation. And each situation turns on its merits. So for the most part, the prosecutor or the prosecution ought to ensure that all material necessary to assist the magistrate to make an informed decision is at the disposal of the magistrate in order that the magistrate may protect the public as the case may be. So for the most part, it's simply inefficacy as opposed to, someone being purposely negligent or deciding purposely to withhold evidence from the court.
Okay. So from what I hear from you is that you'll rather be on the side of those who would say that this was a genuine omission of information, not that they sat down and said, we will have to withhold this information. Let's take out this information from what we're going to present to the magistrate.
Yeah, I would take that route, even though I would subtract the word genuine from it.
Okay.
Right. The fact is, information has been withheld, and information that ought to have been within the knowledge of the prosecutor, at least according to what the magistrate is saying. To that extent, one can safely say, perhaps, that there was no wrongful or ulterior motive for the withholding of that information. I've worked in the prosecutions department for the longest time. That's prior to going into private practice. And you do discover, for the most part, that these are errors that result mostly on account of inadequate training or poor preparation on the part of prosecutors, that is state attorneys and prosecutors at the DPP, and sometimes public prosecutors that are with the police. But it's hardly ever a situation of, willful withholding of information from the court.
Okay, so if it is not willful withholding of information, we could then say that at this time you would expect that people who are assigned cases such as GBV or deal with GBV are what you would call the cream of what the institution have. In this institution, in this case, whether the police, Botswana police, or DPP itself, and that any mistake that can be made, there's really a small room for mistakes such as this one. I want to go further to say to you that one would say that we don't expect a mistake of this nature in a case, in instance, where life, it's all about protecting life. And wouldn't people be justified then to say that, look, then you failed at work, these two institutions, one of them failed to assign highly credible, the cream within the team?
Yes, ordinarily, you're going to discover that prosecutors, for the most part, are spread thin at the DPP. Having worked there, I know that for a fact. So the manner in which allocations of cases is done is such that not much regard is had to experience. I'm not saying experience is sidelined in literally every case, but you would discover that in some instances, relatively inexperienced prosecutors handle matters which ought to be handled by those probably more senior and more experienced than them. Not on account of any negligence on the part of the department, but on account of the fact that the job has to be done. Sometimes it's simply a question of, if we don't send this person, there are no prosecutors, so who are we sending? The court can't be sitting without a prosecutor. So I'm saying this in order to give a perspective to this whole issue, because in as much as we have to demand responsibility in the hands of the prosecutor, we must equally understand that the prosecutor works within a system. The system which also has obligations to equip this prosecutor and to prepare the prosecutor for the task for which the prosecutor is assigned, especially talking about cases that can potentially put society in danger, or serious crime, or violent, or cases of where violence is likely to be meted to a member of the public.
Okay, so we could say that what we are learning from this, the utterances made by the magistrates and what we are explaining right now, is that it could also be revealing much of what we are not aware of within the DPP, the Botswana police, that they're actually running short of human people who are capable of doing the job, so much so that they then just have to give whoever is available at that time. It's exposing.
Correct. It could be that they are short of people who are capable of doing the job, or it could be that people are qualified to do the job but have not been trained to do the job. You know, you come from law school with a law degree, or you are a police prosecutor with maybe a diploma in law or even a law degree. Some of them do have them. But you have not been polished to deal with this particular aspect. You don't come out of law school or out of college a fully baked practicing lawyer. The school gives you a qualification. Courtroom experience and how to handle matters in court, that's a completely different subject. You've simply been equipped to be in a position now to learn court. So many a times you discover that the people do have the relevant qualifications, they've got the degrees, but the necessary training that equips them to deliver the job in a manner that would assist the court is what is lacking.
If you were to give assistance or suggestions to government or to DPP, what would you say the first thing they should be quick to do to improve what lacks within the system?
Firstly, we would start at the police, because those deal with the bulk of cases, especially on the ground. In the rural areas, police prosecutors are in literally every court, every single day. And generally speaking, not all of them, generally speaking, they do court work without legal training. They do court work on account of training that they have learned over time, simply going to court, listening through cases, and then the next thing you are given a docket to mention you deal with bail applications. You don't even have a diploma in law, not even a certificate in law, but you are there in court squaring up against a fully qualified lawyer. Now, the first thing, realizing this shortage, is police prosecutors, or those that are assigned court work, have to be trained to some cognizable minimum to say that this person has been walked through the court process, drilled through the loss of evidence, taught how to deal with bail applications, etc., etc. So there's got to be some training for them. And when it comes to the lawyers, say, who are mostly, for the most part, they are the DPP. When it comes to the lawyers, that's more a question of making sure that they are refined or their legal abilities are enhanced to square up with private practitioners in these cases, because certainly they will beat private practitioners. And, you know, I'm going to court, I'm paid, my client wants bail. He's not looking for excuses. So I'm going to bend the midnight oil, working towards getting my client bail. The next morning, I meet an unprepared police prosecutor who has not been trained to deal with bail applications. The situation is immediately skewed in favor of my client. You know, so the situation is immediately skewed. So we've got to find some balance somewhere, and it all comes down to training of those that work in court. I'm not going to put blame for all these things on prosecutors. They work under extremely trying conditions, for the most part, ill-resourced in some instances. You may well discover that this prosecutor didn't even know there was a restraining order. It's possible. The prosecutor didn't even know that there was a restraining order, because sometimes restraining orders are obtained by the individual at court. And that information, systemically, is not within the knowledge of the prosecution. Someone has to tell the prosecutor that there is a restraining order. Either the police or the individual, the complainant, if they have had access. You may well discover the prosecutor didn't know at all, and it wasn't even an omission on their part. They simply didn't know That's a possibility. I'm not saying it was like that, but it's a possibility. So before perhaps we are conclusive about it, we need to do a bit of fact-finding in order to ascertain where the problem really, cropped up, whether it was a systemic failure or the problem was with the prosecutor themselves.
So in this case, people are pointing fingers. Obviously, they've went in with the flow with what the magistrate have said. There are a few who say that, look, this is the system as it is. One, this is the man who is accused of killing the woman. Also has the rights. They say that he has the rights. There's nothing wrong with him even asking for bail again. Would it be surprising if he's granted bail based on the argument that will be presented by the R24 representing him? Or would it surprise you if he were given a bail?
No, it wouldn't surprise me if he was given bail. Because, bail is granted on the basis of evidence led before court. You see, in this case, the magistrate...
whoever convinces the magistrate...
Whoever convinces the magistrate by putting the best evidence before... Remember, the magistrate comes as a blank. And in this case, the magistrate is right, completely right to point at the prosecution.
Yeah.
She's not wrong in any way. She's completely right because she comes in blank. We are the ones who are supposed to give her facts and circumstances that make this individual not to be a proper candidate for bail as prosecutors. Because the defense, on the other hand, would be giving reasons why he is a proper candidate for bail. So when some information comes much later that could have influenced the magistrate's decision, she's completely right to say, prosecution, you have failed the public. So she's completely right. What I'm pointing out are simply the systemic problems, but with the magistrate, she's 100%.
I'll actually pick that point where you systematic problem here is that we may be looking at the end of it, which is the arguments advanced in court, and then totally ignoring where it started. And if we get carried away with the what happened at the end, we may totally forever even fail to address the root cause of what eventually happened in court. Is that the position?
Maybe
the root cause being the failure to address the challenges, resource challenges, fully preparation of the workers themselves, being lawyers, prosecutors.
Correct. Nothing. To the extent that the criminal law system can protect the public, including the deceased, may her soul rest in peace, nothing can substitute for prosecutorial training. Absolutely nothing can substitute for prosecutorial training. If we have trained the prosecutors, we can then hold them responsible for the errors that they may make in court. But like I've indicated, these are specialties. We've been around this block so much. We know out of experience as private lawyers how to defend a bail application or how to make one. And I've been here 25 years doing the exact same thing since graduation. I'm squaring up today with someone who's still learning that in a case where someone's life is at risk. It's not so much about experience, but it is simply about, has this person been trained to shoulder responsibility of this magnitude? And has this person been equipped to shoulder responsibility of this magnitude and to assist the court? Who told the prosecutor to begin with that there was a restraining order? Before I even judge the prosecutor, that's the question I will always ask, because that's not information that is immediately within the prosecutor's personal knowledge. Someone needs to tell them. Even me, going into the DPP, with all the experience I may be having or not having, If no one had told me, and I was the prosecutor, that there was a restraining order, I would not have told the magistrate about the restraining order, and the outcome would have been the same.
The outcome would have been the same.
The outcome would have been the same.
All right. In short, Attorney Kgosi Ngakaagae is saying the output largely reflects the input, at the end of the day.
Thank you very much.
Thank you very much, Ngakaagae. I appreciate for your time for gracing the Atlas today.
Thank you.
Thank you.
Thank you.